Hello everyone, welcome back. Good afternoon, Barabziz. My name is Gevorg Vardanyan. I will be the moderator of the third panel for today. I am a member of the ICTJ. I'm sorry, Center for Truth and Justice. It's been a long day. Right? So I just wanted to acknowledge that in our presence today we had a lot of students, and some of them were from the Economics and Law College as well as the University, Eurasian International University's law students. So thanks for being here as the next generation of professionals. And with that said, I would like to introduce the topic of the third panel, which will be enhancing victims' representation and support in international criminal justice. And we have three esteemed panelists present, and we will start off this panel with Ms. Megan Hirst. She is a barrister and victims counsel with Doughty Street Chambers from London. Oh, I'm sorry. Let's start over. So then, that's right. We'll start off with Ms. Paolina Massidda. My apologies. Who's the principal counsel of the Independent Office of Public Counsel for Victims at the International Criminal Court. And with that being said, I'll leave the floor and let you carry on. Thank you.
Thank you very much. First of all, thank you very much to the organizer for the kind invitation, and thank you to all the brave ones who are still here for the third panel in the afternoon. And now I try to have a sort of roadmap because, as you can imagine, I was asked to speak 10 minutes about victims' participation before the International Criminal Court. In the beginning, I understood 10 hours, but it's actually 10 minutes. So I really have to be as concise as possible on a matter which is very close to my heart and very broad. So what I would like to do is to start with maybe a brief overview of what does it mean that victims can participate before the International Criminal Court, because not everybody has an idea of how it works. The International Criminal Court is often called as the court in which victims can have a voice, the court of victims, and so on and so forth. It is true that the Rome Statute grants victims the possibility to participate in the proceedings, and this has been seen as a huge step forward in international criminal justice for victims. It's also true that if you look at the provisions of the Rome Statute and at the practice of the court, you may actually realize that this right to victims is still a little bit under construction, despite the fact that the Rome Statute entered into force in 2002, and we are now in 2024. And I would like also to maybe spend some words about these difficulties for victims to effectively step forward and have their voices heard in the ICC proceedings. There is in essence only one provision in the Rome Statute dealing with the participation of victims, which is already says something in relation to how the participation of victims was debated in Rome during the diplomatic conference, and this is paragraph 3 of Article 68, which essentially indicates that when the personal interests of victims are affected, the court allows for their views and concerns to be considered and heard at the stages of the proceedings considered to be appropriate by the court in a manner which is not prejudicial to the interest of the defense and not contrary to a fair and impartial trial. So in a pronouncing paragraph 3 of Article 68, I think it's easy to understand how to some extent it's somehow difficult for victims to already start navigating the system of the ICC. But why it's important for victims to be able to participate? Well, because they have a unique perspective. Despite the fact that very often we think or we say or we heard that the prosecution takes into account also the interest of victims, well, in my personal experience, very often the prosecution and the victim interests are divergent. The way in which victims are looking for justice, the type of accountability that victims are looking for, the temporal scope, the geographical scope. Victims have very distinct interests, and the beauty of the court is the possibility for victims to step on, to have an independent voice and role before the ICC, making the judges understand the full extent of the victimization. Very often in the proceedings before the court, this extent of the victimization is not so much emphasized by the Office of the Prosecutor. They have a different focus, it's absolutely normal. But for victims, it's important to tell the story the way in which they suffer it. It's not the way in which strategically the prosecution wants to tell it, it's the way in which they suffer it. And it's very important for them because it's part of the recovery. It's part of turning the page. And I would like to underline that because I think that it's important to understand how much victims could contribute, much more than how they are already contributing before the International Criminal Court. The second point that I would like to stress, you have heard this morning issue in relation to referral, the possibility for a state to refer a situation before the ICC, and discussions in the previous panel, the first one in relation to how to eventually make a referral. On this point, I would like to note that there is a useful tool for victims to actually address the court, Article 15 communication. Article 15 communication to the prosecutor allows victims to send information to the Office of the Prosecutor. This information could eventually push the prosecutor to open proprio motu an investigation. And this is a tool that often is, I would say, forgotten, but it's not really sometimes in the picture. And I think it's important to underline that because it's part of the appropriation of the rights of victims to address the court and to have their voices heard. Third point, how the court can facilitate victims' participation. Within the court, we have a number of sections and offices which are dedicated to support and help victims. I will mention three so that everybody understands. The participation of victims at the ICC is a quite complex system. A number of sections cooperate and coordinate the work in order to allow victims to do so. The victims' participation and reparation section within the registry is the first section with which the victims are normally in contact if they want to address application forms for participation or if they want to know about how to participate. We have also a victims and witnesses section, which is in fact the section in charge of the well-being, protection and dignity of victims and witnesses appearing before the court. And then we have an independent office, the Office of Public Counsel for Victims, which I am heading at the moment. And this is an independent office within the court composed of lawyers. And our task is twofold. On one side, we are tasked and appointed to represent victims directly in the proceedings before the court. And on the other side, we have also the task of advising external lawyers who may represent victims before the ICC. Fourth point, I would like to go to some challenges, just to maybe stimulate also a little bit the discussions maybe later on. First of all, I would mention the specificity of each situation before the court, to which the court itself but also lawyers representing victims have to adjust. If I represent a victim in the situation of Venezuela, or I represent a victim in the situation of Central African Republic, it's a complete different universe. The way in which strategically you have to approach the questions, or even the type of victimization, or even the relationship with the clients is completely different. And this has to be understood because you can only represent victims if you fully understand their extent of victimization, their story, what they want, because they want, why they want to participate, what importance to them, what matters to them. You are in court to actually be their voice because they cannot be there. So it's essential that you impregnate yourself of the situation of the victim. Specificity is very important. The background, some knowledge of a language, the culture, everything, the knowledge of a conflict. It's very important also to establish the relationship, the trust relationship with victims. Second, the challenges in addressing very complex legal issues with victims. You may have victims who are lawyers or judges, it happens to me, but you may also have victims who never met a lawyer in their life, but have to understand what justice is, how it matters, what a lawyer does. I had a client in Uganda asking to me, what does it mean that you are a lawyer? What's exactly your job? And I had to explain to him. The difficulty of the length of the proceedings and of the distance of the proceedings from the places where victims are. The language barrier somehow can be sometimes an issue. The fact that not very often you will see always consistency in the way in which the decisions of chambers are issued. We have cases at the court in which the same legal issue has been ruled before a pre-trial chamber and B before another pre-trial chamber, not even a chamber on another level. And this is very complex. It's complex for the victims to navigate and it's complex for lawyers to adapt himself or herself to the situation. The final observation that I would like to mention is the very important role that lawyers have in shaping what victims can do or not do in the proceedings before the court. I think we had very positive outcomes, which became positive outcomes because of the fight of lawyers. Situation in Afghanistan, the possibility to stand before the appeal chamber, despite the fact it's nowhere there is a provision of the court allowing that. The possibility of presenting evidence at trial was challenged in the first trial before the ICC in the Lubanga case. That possibility, which was a decision by the trial chamber, was actually challenged by both the defense and the prosecution. And now it's a standard proceeding that victims can present evidence at trial after the presentation of evidence of a prosecution. The possibility to have something to say at the level of investigation. This is a very, I would say, new avenue for victims, which I'd like to stress because I think that in the Armenian context could be interesting. For a lot of years, there was a sort of barrier in having the prosecutor as interlocutor in the provision of information. Victims were seen a little bit like too much interfering in the role of the prosecution as master of investigation. We have arriving at this moment in a situation in which there is much more dialogue, in which victims are more taken into account. And why I would like to stress that, because actually at the investigation stage, it's your chance to get right the geographical scope, the temporal scope, the type of crimes, the type of accountability. If you start at the ICC, in the ICC system, to make these kind of challenges, after the confirmation, you will have no chance at all. So there is much to do. Victims are to some extent officially heard before the court, but I do believe that we still need a little bit more to push, particularly at the level of the preliminary examination investigation and possibility to appeal some of the decisions which affect victims, which at the moment is not possible at all in the Rome Statute, in order to have really effective the victim participation before the ICC. Thank you very much.
Now, our next presenter will be Ms. Megan Hirst. As I indicated earlier, she's an Australian attorney practicing as a barrister at Doughty Street Chambers in London, and she specializes in international criminal law, specifically representing victims. From 2009 till 2015, she worked at the registries of the International Criminal Court and the Special Tribunal for Lebanon on victims' participation issues. Since 2015, she has represented victims in international proceedings. Ms. Hirst was part of the team representing the Ugandan victims at the ICC in the Angwan case from 2019 to 2022. And she was international lead co-lawyer for civil parties in case 002/02 at the extraordinary chambers in the Court of Cambodia. She continues to represent victims at the ICC from Afghanistan, Bangladesh, and Myanmar. And with that being said, welcome.
Thank you very much, and thank you for humouring our agreement about the ordering of our presentations, because now I can rely a lot on what Paolina has already explained. As Paolina explained, the essence of victim participation is the idea that victims have their own voice in the proceedings. Now, at the ICC, we have a bit of a semantic argument always about whether we can call victims parties or not, but regardless of the terminology, you can think of victims as being some kind of a quasi-party in the proceedings, so that you don't only have the prosecution and the defense, but there is a third lawyer in the courtroom, the lawyer who represents the victims. If we broaden the concept even beyond that, you could imagine situations where the lawyer for the victims not only litigates to the judges, but also goes to engage with different parts of the court, the registry, the prosecution, the state's parties, for example. So I always say to people that what we're really talking about when we talk about victim participation, the very essence of it, it's really about legal representation. It's about victims having a lawyer who can assist them, advise them, and speak for them, both in the litigation and in the different bilateral discussions that happen around the litigation. And when we talk about legal representation, we also have to remember that it's a two-way street and it's a long-term dynamic process. These are not short cases. These are not proceedings that last for a few weeks, a few months, a few years. These are proceedings that can last for decades. And legal representation means being the bridge between the victims and the court, all different parts of the court, over that period of time. It's not only going to the court and making arguments for the victims, but it's going back to the victims constantly and explaining to them what's going on. Even when it seems like nothing is going on, it's asking them what matters to them and taking that information back to the court. It's a dynamic, ongoing process, and it's about a relationship with the victims. Why do we do this? What is the benefit of it? Paolina has mentioned a few things. I want to add a few more comments. Now, obviously, at its most basic level, victims, like any litigant, they want outcomes. They have outcomes that they want. They might want to go back to their land. They might want to see a particular perpetrator punished in a particular way. They might want a particular kind of reparation. So, of course, like any lawyer in any proceedings, we are fighting for these outcomes. But we're also very focused on procedure. And Paolina spoke already a little bit about the relationship with the prosecution. It's really important to have in mind that victims are not there at the court to be a second prosecutor. We don't have the resources resources that the prosecution has. We don't have access to investigation means that would enable us to get to the bottom of the crimes in a detailed way. So we have to think strategically about what we can do, what our clients want us to do in a particular case. And more often than not, what that involves is actually trying to hold the prosecution to account in different ways, trying to make sure that the prosecution is thinking about the interests of victims, that the prosecution is doing its work in ways that are beneficial and helpful to the victim. So it sometimes surprises people to hear this, but I feel in my work that I have just as much conflict with the prosecution as I have with the defense, because sometimes the prosecution is doing something in a way that the victims aren't happy with, or focusing on crimes that the victims would rather the prosecutor focus on different crimes. So we are there in large part, I think, to make sure that the prosecution does its work in a way which is victim-friendly. Now, sometimes that means you have a great prosecution team and there's nothing much for you to do, but you can also be happy when that's the case, I think. But the third thing, and for me this is actually the most central thing that we do in victim participation, is about the connection that we try and build between the victims and the court. And at the beginning of this concept at the ICC, the idea of victim participation was about trying to move away from a system where the victims were simply instruments used by the prosecution for its case. Victims were used when it was convenient to the prosecution, when they had information which helped the prosecution, but not otherwise. They were somehow objects in the process, without much control. What we try and do now is say that the victims are active, that the victims can decide which issues matter to them and bring those matters to the court. What that's about is making sure that the victims are advised, that they are informed, and that they are able to be heard. And actually, this is much wider than the litigation itself. It's in some ways almost a psychological process that we're engaging in, because we are dealing with people who, in my experience, almost invariably are among the most disempowered people. They will have been through something terrible and traumatic, and usually they will feel that the international community has lost interest, doesn't care, that people are no longer listening to them. So what we are essentially trying to do is to counter that. We are trying to empower them, we are trying to give them information, we are trying to make them feel that somebody is fighting for them, listening to them, and taking their voices out to the world so that they will be heard by decision makers. Now that has a value regardless of the outcomes which you manage to achieve in the proceedings. How effective are we at doing this? At the ICC, Paolina has already mentioned some of the challenges, and I wanted to bring it back a little bit to the situation that you have here in Nagorno-Karabakh. Here we are at the very earliest stages of proceedings. We don't even have a preliminary examination open. What does that mean? Well, for victims, unfortunately, this is a difficult stage. First of all, there is no legal aid from the court at this stage for victims to be represented, so victims' lawyers will have to work for free or find their funding privately for something which is a huge job, very time-consuming, requires a lot of resources, including travel and language skills. Even more fundamentally, there are questions about what standing victims have at this stage. At the ICC, even at the investigation stage, even once the prosecution is already investigating, it remains a very contentious question how much standing victims have. As Paolina mentioned, we have different decisions from different pretrial chambers. At times, the pretrial chambers have been ready and willing to listen to filings from victims on matters that affect their interests. They have been willing to listen to victims suggesting a wider temporal scope of the investigation. For example, in the Bangladesh-Myanmar situation, we managed to do a filing asking the chamber to consult about the possibility of in-situ hearings or hearings outside the Hague. But for example, last year we also had a situation where we filed to the judges to ask them to require the prosecutor to follow a protocol in its investigations at the earliest stages, including a requirement that victims could have a lawyer present during prosecution interviews. And the chamber simply said to us that they wouldn't decide the question because victims didn't have standing to bring the issue. At the preliminary examination stage, we have similar challenges. There have been instances where during a preliminary examination, victims have been heard. At the end of the Columbia preliminary examination, victims brought a filing to say that the prosecution had ended the preliminary examination and refused to open an investigation wrongly. And the chamber did accept that filing, but it simply said, well, we can't control the prosecutor's decision on this. The prosecutor has discretion. So victims have big challenges at this stage. The chambers may not receive your filings, and the framework of the ICC gives the prosecutor enormous discretion at these early stages. So even if the chambers are willing to hear from you, the chambers may simply say, we can't tell the prosecutor what to do. Is it still useful then to try and be active at this early stage? I still always say to people that I really believe that it is important to organise, and even from an early point, and there are a few reasons for this, but I also would say to people that the ICC should not be treated as an end and a strategy by itself. I think the best victim representation that we see these days at the ICC in the early stages is part of a holistic strategy which treats the ICC as one avenue for litigation among many others. And from what I've already heard today, I think here you're in an extremely strong position to take an approach like this because you already have skillful lawyers who are doing strategic litigation in different avenues, and the ICC can be built in as one of those avenues, but perhaps not the only one. I do think it's important that you consider the ICC as one of those avenues. One of the reasons is because even if nothing is happening at the ICC, it's important for the victims to understand what is and isn't happening and why it isn't happening and what can and can't be done. It's important for the victims to know that efforts are being made. It's possible for lawyers to take steps which are outside the litigation framework, such as engaging with states parties to request a referral or engaging with the prosecution to push for an Article 15 process. And if one day something does happen, then Armenian lawyers will be in a much stronger position to engage with the court and represent those victims effectively if they have started organising themselves now. The court is a hugely opaque institution. If you haven't been there, if you haven't engaged with it, it takes quite some time to work out how things operate. The earlier that you start to engage and to organise yourself and to understand what your clients would want from the court, the better off in the long run. Paolina's office is there to serve as a part of that process. The ICC Bar Association is also very happy to support lawyers from national systems who are interested in learning about how things work. So I would just finish by encouraging those who are interested to get involved early and to reach out to those others at the court for support.
Բոլոր նրանց, ովքեր հետաքրքրված են դատարանի ներքին կառուցվածքով։
Thank you, Ms. Hirst. And our next panelist is our very own Sharmagh Mardi from CFTJ. Ms. Mardi has an LLM from the American University of Armenia. She has joined the organization in 2021, shortly after the war in Nagorno-Karabakh that started in 2020. And she's involved in various projects with the organization, including collecting first-hand testimonial evidence from the victims, survivors of the conflict, prisoners of war, family members of those who were missing in action, and she has also worked on conducting human rights research, preparing reports, and training students. With that being said, I invite her to the podium.
So, dear guests and colleagues, first of all, it's an honor to join this panel today as a member of CFTJ alongside such distinguished experts. As already mentioned, my role involves collecting first-hand testimonial evidence from survivors of armed conflicts, and over the past 3 years, I've had the privilege of working with hundreds of witnesses who have shared their harrowing experiences. And today, I'm here to represent the victims of Nagorno-Karabakh affected by deportation, shedding light on their struggles and expectations. Their stories are heartbreaking and reveal profound suffering. So, for nearly 10 months, ethnic Armenians living in Nagorno-Karabakh have endured a blockade that has cut them off from the rest of the world, including the Republic of Armenia. On December 12, 2022, state-sponsored individuals from Azerbaijan posing as eco-activists in civilian clothing set up tents and closed the Lachin corridor. Eco-activists were later replaced by fully equipped Azerbaijani military personnel. This blockade imposed by the Republic of Azerbaijan has severely disrupted the flow of essential goods, medical supplies, and humanitarian aid to more than 120,000 Armenians living in Nagorno-Karabakh, including 30,000 children. Eyewitness testimonial evidence collected by CFTJ reveals that as a result of the blockade, families went without food, children without education, and the sick without medicine. This was not just a physical blockade, but a systematic and deliberate strategy to force Armenian population into submission and drive them out of their ancestral lands. On September 19, 2023, Azerbaijan launched a military offensive against Nagorno-Karabakh, forcing over 120,000 Armenians to flee their homes under the threat of destruction, torture, and killings. Azerbaijani forces actively spread videos and photos on social media, along with threats of rape and murder, to advance psychological propaganda, spreading fear among the Armenian population and supporting their plan to drive Armenians out of their lands. An Azerbaijani Telegram channel with over 11,000 followers circulated photos of missing Armenians who disappeared due to Azerbaijan's military actions, along with threats of rape and murder. For example, above a photograph of children, it was written, "Children of wars should clean toilets and work hard in mindful pennies." And under the same photograph, it was stated, "They are lost. Whoever finds them, rape them, cut them into pieces, and feed them to dogs as dinner." Testimonial evidence collected by CFTJ also reveals that the Armenian population of Nagorno-Karabakh was subjected to terror, particularly before their forced displacement and during the assault on the Hague Bridge. A witness from Nagorno-Karabakh's communications office reported that on September 20, 2023, as the conflict escalated, they were working from a basement when an alarming SMS began circulating. The message said, "We will soon arrive from the Grey Wolves." And for clarification, the Grey Wolves is a Turkish ultranationalist paramilitary group. As someone who collects testimonial evidence from war survivors and the victims of Nagorno-Karabakh affected by forced deportation, I am deeply aware of their dire situation, their loss and desperation. They are left now with nothing. Left with no other choice, they were forced to leave behind their possessions and their loved ones they had buried in Nagorno-Karabakh, fleeing to save their lives and those of their families. They have faced unimaginable bloodshed and sorrow, and now even their belief in justice is fading as they face a harsh and uncertain future. It's our responsibility to restore their hope by speaking up for their suffering and advocating for the justice they have been denied. While each witness's story is unique, there is one common desire: to return to their lands and homes. After witnessing the mass atrocities committed against them, enduring profound mistrust and existential threat to their identity, the people of Nagorno-Karabakh cannot imagine a future under the authority of those who inflicted so much pain and suffering. Asking them to return under these conditions amounts to asking them to surrender their identity, their rights, and their life. This is not just about a piece of land, it's about the survival of a people, a culture, and a way of life. These victims are not just a group of people, they are individuals whose rights have been violated. When a crime is committed against a single person, the justice system responds with investigation and legal proceedings. Yet today we face a grave injustice. Mass atrocities have been perpetrated against the people of Nagorno-Karabakh, and suffering is met with silence and inaction. Their expectations are clear: recognition of their suffering, accountability for their crimes committed against them, and rightful return to their homeland, and also guarantees for their safety and dignity. And it's very crucial that we amplify their voices and support their pursuit of justice. So, thank you for your attention.
Thank you, Sharmagh. Thanks again to all the panelists. And at this point, we'll start the question and answer session. And I would like to open it up with my first question to Ms. Massidda. Having years of experience representing victims at the ICC particularly, what are the main challenges faced by the victims at the ICC and receiving reparations?
Thank you. Okay, reparation is another chapter. Thank you very much. I think it's important, first of all, to underline that in the scheme of a Rome statute, victims may wish to participate in the proceeding, which will mean that they will present their views and concerns, normally via a lawyer. But if an accused is convicted, then victims will also have a possibility to have reparations. So the reparation proceedings are only triggered if an accused is convicted. So this is the first challenge, I would say. Because, of course, if the accused is not convicted, then there is no possibility at all for victims to access this measure of compensation, indemnization, or any kind of reparation. Why it's a challenge? Because in my experience, it's true that the first thing that victims ask is to get justice, to know the truth, to understand what happened, so that this is not be repeated. And this is certainly their first interest. But once the truth is established, they also have an interest in getting reparation, in seeing that the international community acknowledge not only the crime, but also the consequences and the effects of the crimes. And that to some extent, these effects are, I always say repair into brackets, because I don't really think that the word repair is sufficient enough to describe the dimension of the effects and consequences, and also because I don't think that it's possible to repair what a victim suffered. So I would prefer to say something that can support or assist the victims in turning their page and to regain their dignity and to some extent to rebuild their lives. So the first challenge is what if the accused is not convicted? The second challenge is that reparations normally arrive after a trial, after a very long journey, which can last for, let's say, an average of 6-10 years. So the moment you arrive at the start of a reparation phase, so at the moment in which you have to plead and argue for the type of measures, then victims have already done a lot of their life with the consequences of what happened to them. So the needs that victims may have at the reparation stage are necessarily different from the needs that the victims had when the crime was committed. And not only that, in order to implement reparations before the court, because of lack of resources, at the moment we have an average of 3-6 years. So it means that when you actually arrive at the implementation of a reparation, your needs are again different from what has been pleaded before a trial chamber, which issued then a reparation order on what is pleaded as needs at that point in time. So there is the challenge of flexibility, I would say, in implementing the reparation measures, which take into account the long effect of the trauma and the fact that reparations are implemented at a very late stage, considering when the crimes were committed. The third challenge, and I will stop there because I think I could go on and on, but the third one is the lack of resources. I take the last reparation order in the ongoing case. The trial chamber awarded 52 million euro for the reparation in ongoing, including an award of symbolic reparation, 750 euro per victim, as a symbolic reparation for the recognition of the harm they suffered. Now, Mr. Ongwen is indigent, so this will mean that the Trust Fund for Victims, which is a specific entity created by the Assembly of State Body to implement the reparation order, also for the assistance, we are talking of the reparation order. At the moment, the Trust Fund for Victims has declared publicly that the amount of money that they have for ongoing is zero. And they have launched an expression of interest for organization which could invest or help in trying to find funds. So this means that these people, now I recall that the crimes for which Ongwen was convicted were committed between July 2002 and December 2005. Okay? So we are now in 2024. The Trust Fund for Victims declared publicly that they hope to be able to implement the first award for reparation in September 2025, which will mean 20 years after the events.
Now, just to follow up on that, now it seems like, I say this just because we do have students amongst us, and it may be something that the professionals present have some knowledge about, but how do you go about collecting on those judgments of reparations, and do you have any success stories actually?
Yes. Yes. There are some successful stories. Back to the first reparation order in the Lubanga proceeding. Lubanga was convicted of a crime of enlistment, recruitment, and use of children under the age of 15 in hostilities, and for events committed between 2002 and 2003. Reparation started, the implementation of reparation started 2 years ago. We are now in the third and last year of implementation. In which way it was successful? We had a number of former child soldiers who were able to not only complete their secondary education but also go to university. So, and we have people at the moment we have 2 doctors who are serving in their communities. We have 1 engineer also serving remaining in DRC. So we have some successful story. In the Katanga, the second reparation order, which has been completed, the only one completed so far before the ICC, the Katanga reparation. Katanga was convicted of 1 single attack in Bogoro, 1 single day. So the extent of reparation was to some extent easy because it was only 329 victims compared to the almost 3,000 in Lubanga, and the projected 75,000 in Ongwen. So it's very easy. 329 is. Wow. And in that specific case, the chamber decided to award individual reparations. So each victim was actually provided reparation tailored directly to their needs in terms of housing, education, housing or restructuring of their housing, education, and possibility of income generating activities, including the possibility of buying again the animals which were looted during the attack. It was a very specific one. In all the other cases before the court, of course, the judges decide for what we call collective reparations. Sometimes with an individual component, which will mean that the reparation measure will be targeted to the needs. In Ongwen, we have a new idea, I'll put that way, of the chamber, because the chamber decided to award collective community-based reparation, indicating in the reparation order that they understand community as the community of victims, which at the moment is still unclear even for the lawyers. So don't ask me exactly what does it mean. What I understand is that there will be a need for the trust fund to identify the different categories of victims, victims of sexual and gender-based violence, former child soldier, victims of the attack, and then to target the needs of these different categories and subsequently then design different reparation measures depending on the needs of that community of victims.
Thank you, Ms. Massidda, and I would like to slightly move the topic to the perspective of the victims and ask Ms. Hirst, when victims approach you for representation at the ICC, what are their expectations?
I never know whether this is a linguistic issue or not, but at the ICC this word expectations, it's quite toxic. We like to proceed on the basis that people should have no expectations. And actually, the primary mantra of many people in the ICC is that we need to manage expectations. We need to manage expectations, which means we need to lower expectations. In my experience, when I first meet people, and again, I want to come back, and I think Sharmagh said it. Victims are individuals. They have different hopes and aspirations and asks. So it's always a little bit tricky when you find yourself generalizing. But in the time that I have been doing this, I have to say that people's expectations are actually quite low already, because usually by the time you meet people, they have already been profoundly disappointed by what the world is doing for them. But at the same time, they have hopes, of course. They have things that they want. And those things, as Sharmagh said, are hugely variable. They want to go back to their homes. They want to see justice in the form of punishment, perhaps, or recognition, or they want reparations. They in a million different forms. So that they have many hopes, But I think, coming back to what I said before, I think we can't promise all these things to them, and I don't think any lawyer out there tries to. I actually don't think there is anybody in the ICC system who is out there actively raising expectations. But what we try and do at its essence, I think, is to give them back a feeling of being heard, and hope that with that we can also at the same time achieve some of those outcomes for them in the long run.
Of course.
When I hear this question, which is actually quite often, I always like to say victims have legitimate expectations, and they should have expectations. Now, I would like to pose the debate on another level. Is international criminal justice up to the standard to take up the victims' expectations?
And on this topic, I would actually want to get more specific and ask Ms. Mardi, what are the expectations of the deportees, victims from Nagorno-Karabakh, based on your experience interviewing them? What are they expecting in terms of returning home or reparations of some sort?
Accountable, the ones responsible for their forced deportation as crimes against humanity, and considering the fact that the deportation of the Armenian people ended on the Republic of Armenia, the court has the jurisdiction to also consider that case. So I think they have grounds to anticipate that the court will take all measures in order to ensure accountability and justice.
Thank you. And I'd like to come back to Ms. Hirst and ask what an organization like us can do to try to give hope of some sort to the victims from Nagorno-Karabakh, since we're far, far away from filing any type of ICC complaints at this stage.
Yeah, it's a really good question. It seems like a lot of it you were already doing. I think I could say as far as the ICC is concerned, civil society organizations, human rights NGOs play a really important series of roles at the ICC in a way which is quite different, I think, from how non-government organizations engage with the national justice system or with other international court, state to state international courts. There are a range of different roles which ICCs are sort of given at the ICC. None of it is very clearly defined, but I think there are a number of roles that are really important. One of them, I think, is outreach, leaving aside the question of legal representation, even just bringing information, accurate information, clearly explained in a language that people can understand. I don't just mean a language as in Armenian or English, but terminology that is accessible, meaningful to people so that they understand the limitations and the possibilities. This is extremely important. Monitoring the court and what the court does so that you're able to get that information. In the early days of the court, there was a lot of funding for NGOs and there was a lot of public information out there as the NGOs went to watch what was happening at the court and put information out there on the internet. These days there is much less of that, and even for those of us in the field, it's really hard to keep up with what's going on. So for lay people, for victims communities, it's really hard. So being that bridge just in terms of information is really important. Then there is the very vexed question of intermediaries, which some of you might have heard about. The court, different parts of the court, the registry, the prosecution, victims' counsel, defense counsel, we are all often finding ourselves with some logistical struggles because maybe we don't speak the language, maybe we are far from the victims physically, maybe there are security issues. So we are always dependent on people on the ground to come between us and the victims, to be intermediaries, a bridge between us and the victims. And very often that role has been played by local civil society organizations. It's an important role, but it's a very difficult maze to navigate because there may be different parts of the court who want to call on you. There are various protocols for how you should operate, but none of them are really strictly observed. So this is an important role, but it's also a tricky one. And then, of course, there is the question of legal representation and for victims. Very often, in the absence of proper legal aid from the ICC, human rights organizations have stepped up and said that one of their staff members will represent victims. That's actually quite common, both at the investigation stage, but even sometimes in some cases that has happened right through. I have some questions about whether it's the best way to operate, because I think maybe it limits the other things that organization might want to do in creating the potential for conflicts. But basically there's a huge range of different things that an organization can do, and I think it's important for an organization at the outset when engaging with the ICC to kind of look at all these options and decide what are we going to do, because once you get in one lane it can be a little bit tricky to switch over partway through. But I also think what you can do is facilitate what the victims want. I mean, if the victims want multiple of these things, an organization like CFTJ can facilitate that. In my work representing victims, Rohingya victims in the Bangladesh-Myanmar situation, there is no legal aid. So I had an organization that was funding me to do that work for some time, and that was immensely helpful because it meant that I could really devote a lot of time to it. So that's, you can fund lawyers even if you don't produce them from within your organization. But really there's a huge number of different things you can do. So if anything, the challenge is prioritizing all the needs, I think.
Thank you. And now I would like to move on to another question, and this is addressed to Ms. Massidda. What role can the attorneys, lawyers play in... I said, what role can lawyers play in advancing the effective participation of the victims in the International Criminal Court proceedings?
I strongly believe that the vast majority of things that victims can do at the moment before the ICC is because lawyers pleaded for that. Victims' lawyers pleaded for that. I'm really very convinced about that. I can give a few examples. One I already gave was the issue in Lubanga, when we pleaded for the possibility to present evidence. It was allowed by the chamber, and both the prosecution and the defense appealed that decision, and then it was confirmed on appeal. I can think of a number of issues in terms, for instance, of legal reasoning. All the discussions in relation of forced marriage and how forced marriage should be included as a crime or not, or understood as other inhuman acts. This was all pleaded by the victims' lawyers. The Afghanistan situation, allow me to tell that, the Afghanistan situation, the appeal was won on an argument pleaded by the victims, not by the prosecution. And the argument was that for the pre-trial chamber was unnecessary to debate on the interest of justice. Now, I remember very well, because I was amongst the lawyers pleading that, and I remember very well a question by the then Judge Prost, who was sitting on appeal after our intervention, to the prosecution, indicating, have you heard what the Office of Public Counsel and other lawyers are saying? What do you think about this issue of the interest of justice? And the prosecution said, we will leave it to the discretion of the chamber. I mean, come on, for once that you could say, I agree. I mean, it was so simple. And by the way, we won on that argument. So why I'm saying this? Because sometimes it's very difficult to see in the jurisprudence of the court for someone from the outside which type of contribution victims can give. And they can give actually a great contribution on the level of understanding victimization, but also on how to plead in order to interpret the law in a broader way. Another example, just because we are conversing. In the Lubanga case, there was a big issue during the trial, because the prosecution decided not to include in the charges any sexual and gender-based crime. It was a big issue. Why? Because the vast majority of our clients, male and female, by the way, but the majority was female, when in speaking with us, the first thing that they said to us was, well, but my problem was that I was raped each day. My problem was not really that I was abducted and used in hostility. My big problem was that I lost my dignity because I was raped each day. I was obliged to be a sex slave. And this component was absolutely absent from the narrative of a prosecution. Now, this was a vital interest of the victim. So, as lawyers, we decided to try to question prosecution witnesses about the phenomenon. And of course, sustained, until one of the judges, Judge Odio Benito, decided to start posing herself the questions. Now, one thing is to stand up, an object is a victim lawyer, the last in the courtroom, is making the question that you can certainly not stop a judge in questioning, isn't it, Your Honor? So, actually Judge Benito started building a narrative about how the female abducted and when used in hostility were also subject to rape and sexual violence. Now, the result was that in the judgment, despite the fact that, of course, there was no crime of SGBC, but the chamber recognized the phenomenon, and there is even a a concurring opinion of Judge Odio Benito, in which she explains what actually lawyers for victims try to plead, is that the crime of recruitment actually includes a component of recruiting children to be used for sexual slave or sexual activities. And this was very well received by the victims because finally they could see that their story was actually told. What mattered to them was heard and was acknowledged in a judgment.
As we're drawing close to the end of our panel discussion today, I have one last question, and this is addressed to Ms. Mardi. Having interviewed many victims and deportees from Nagorno-Karabakh over the last couple of years, what are the views of the victims in their testimonies regarding what drove them out, what made them flee their homeland? What drove those victims out of their lands, in their own words, as you were interviewing them?
Now I remember a sentence, so most of the victims say that they left in order to save their lives, and it was not possible to live under the control of Azerbaijan. So they just had to leave their homes in order to live.
Thank you, and if there are any questions from the audience, I would be happy to address those. If not, we'll conclude today's our first day of proceedings. Thanks everyone for being present. Thank you all the panelists. Hopefully see you all tomorrow.